guys, what's up? Okay, first I want to tell you a little bit more about my case before I get into the other cases. Really quick summary of my case. My case actually covered 3 specific state-level cases. It dealt with 1 case that had to do with murder and 2 cases that had to do with rape in which the death penalty was imposed in the state of Georgia. And what the Furman decision said was that in these 3 particular cases, that the death penalty was imposed unconstitutionally. And, well, there was a lot of speculation behind that because the reason that the Supreme Court made that really controversial decision is that not that necessarily that the death penalty was unconstitutional, but that it was unconstitutionally imposed in these circumstances. Let me read you something that came from, in this case, there actually was no majority opinion. Each justice wrote their own individual opinion. Where in Gibbons v. Ogden and Washington v. Glucksberg and most other cases, you see that there's a majority opinion put out by the majority of the court, like the people who vote in the majority who win in the case. But this case actually was unique in that it didn't have a majority opinion because each of the justices was so had a different opinion. But the Chief Justice wrote this: "The death sentences are cruel and unusual in these cases, in the same way that being struck by lightning is cruel and unusual. For all of the people convicted of rapes and murders in 1967 and 1968, many just as reprehensible as these, the petitioners are among a capriciously selected random handful upon whom the sentence of death has in fact been imposed. My concurring brothers have demonstrated that if any basis can be discerned for the selection of these few to be sentenced to die, it is the constitutionally impermissible basis of race. But racial discrimination has not been proved, and I put it to one side. I simply conclude that the 8th and 14th Amendments cannot tolerate the infliction of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed." So you can see that not only are we talking about the death penalty here, but also we're talking, you can see that in the aftermath of Brown versus Board, where separate but equal was overturned, you still have people that still have deeply rooted racist tendencies. And so in the aftermath of the United States, in the aftermath of Brown versus Board, you can still see that this is still a prominent issue. And then when it comes to the death penalty is such a unique penalty. It's the highest, it's the strongest punishment that anybody can give you. So it really needs to be safeguarded by objective moral standards, It can't just be imposed whenever you want, so wantonly and freakishly like this justice was talking about. And until Furman v. Georgia, the death penalty was just left up to the states. So in Georgia, which was in the South, where people did not like blacks, generally speaking, the death penalty was a lot more likely to go to you if you were a black defendant than if you were a white one. And so this is clearly very unfair because the death penalty is the worst punishment you can give someone, because the right to life is the most fundamental human right that someone can get. And so I want to address some of the points made about Furman v. Georgia made by the other 2 people who just went. So Anna said that there was no lasting effect from my case because Furman v. Georgia, because the capital punishment in the United States is generally considered to be pre-Furman and post-Furman, but actually that shows exactly how much of an influence it really did have, because what it did is it marked the first intervention of the federal government to deal with the death penalty, because up until this point, it was just left to the states. And so in Georgia, where they hate black people, they can just kill all the black people. But up north, where they don't hate all the black people, then it could be fair. But I mean, that's not fair, because the death penalty is a big enough of a deal that it needs to be regulated by objective standards. So it marks the first incoming of the federal government into this issue. And Anna said that 4 years later it was overturned, so it didn't even make a difference. But actually what Furman v. Georgia did is it established a temporary ban on the death penalty until we could actually establish the objective standards that we needed to allow the death penalty to be imposed fairly and equally upon everybody under the 14th Amendment, so that everybody could have equal protection, so that it wouldn't just be given to black people, but actually be equally distributed, so that if I was eligible, if I murdered someone and William murdered someone, and it was almost in exactly the same case. It was mine was just as bad as his. Why should he get the death penalty and me not? It's not fair. And so that's generally what he was speaking of. But also, because the right to life is the most fundamental human right that there is, Furman v. Georgia deals with with one of the biggest issues in human history, because the whole purpose of government starting in the first place is to defend our human rights, because the government is here to keep us from fighting with each other, to pull us out of the state of nature, as Amelia mentioned earlier. And so, and racism has always been one of the biggest issues in American history, because for 2/5 of our nation's history under Plessy v. Ferguson, separate but equal was considered okay. And so, Furman v. Georgia deals with the two biggest issues the biggest issue in human history, and also the biggest issue in American history with racism. And so, really quick on Gibbons v. Ogden. I'll talk about Gibbons v. Ogden first. He says that Gibbons v. Ogden, okay, let me tell you exactly what Gibbons v. Ogden did. Gibbons v. Ogden did absolutely nothing. And here's why. Here's what Gibbons v. Ogden said. It said that the national government is above the state government. Like, duh. Like, the Constitution didn't already say that, you know? So, honestly, like, all of this stuff that Emilio talked about Gibbons v. Ogden having a lasting effect, about keeping us out of the state of nature, honestly, it didn't do any of that, because all of that was already in the Constitution, and the only reason people make a big deal about Gibbons v. Ogden is because if Gibbons hadn't gone through, then it would have meant that the court was going against what the Constitution said, and it would have been really dumb. Obviously, that didn't happen because it was decided 6-0 that the federal government was above the state government. And so really, Gibbons v. Ogden didn't change anything or have any lasting effect because it didn't make any new laws, it didn't change anything about the Constitution, and everything that happened from Gibbons v. Ogden, honestly, would have happened anyway because it was already in the Constitution. So, on to Anna's case. Anna said that, what did you say? Okay, she said that, Anna was talking about how, okay, Anna's case was decided 9-0, his was decided 6-0, mine was 5-4, and so Anna was talking about how, because it's more influential, because it was what she said, so if you're going to judge based on what she said you should judge on, then you have to vote for me, because mine was 5-4. Oh, man.